Well, good afternoon, everybody. It is now October the 25th, 2024. I am very proud of us for making our fourth week in a row here. We're really showing a commitment. I'm just, making sure I'm committing Friday afternoons to doing training, and I appreciate you working with me on this. We need an army of people, and I'm just dumping everything Connie knows, my brain dump of training. So before we start this week's, I wanted to go back through how we are saving the trainings, how we're making them available. I know it's a little bit confusing. I had never used Google Classroom myself, so I'm uploading it, and I know people need to know how to get there. So this is what the classroom looks like that I've created. And this is the first one, and I'm going to show you what you need. So you have to have a Google email. And then when you have your Google email, you will see this little 9 dot image up here. And when you click on that and you scroll down, you can actually open your classroom application right here. Once you've opened that classroom application, you're going to have a choice to join a class. I'm not going to go all the way back to that home screen because I don't want to get lost in this, but there will be join a class. And when it asks you to join a class, it's going to ask for the class code. So the class code, and since I'm also doing this as an audio recording and not just a video, I am going to give these class codes. The class code is 7 and then small letters YPHEI3. Again, that is 7, followed by the small letters Y is in yellow, P is in purple, H as in happy, E is in elephant, and I as in independent, with a 3 at the end of it. So that's the class code for the very first one we did, which is the advocacy in the child welfare system. This was just our first one, which was a general overview. What does advocacy look like? So once you punch in that class code, you'll get to a page that looks like this. And then after you scroll down a little bit, people make some comments, but you want to go down to the place where it says posted new material. And when you find the little entry, it looks like a page with a bookmark on it. It says Family Forward posted new material, overview of child welfare advocacy. You click on that and it will have the class materials in there. So, for instance, I am recording on, I'm recording with Zoom. After the Zoom training is over, I download it to my computer. I upload it into a YouTube channel. I'm going to show you here in just a minute. I also take the audio recording itself and I'm putting that on Spotify, and I'm trying to also post these separately. So if somebody just wants to listen to the training while they're driving, etc., they can listen to it. And then I take the uh, slides and I print them to PDF, and you have the slides to PDF there. So you can just go through and read them one at a time if you like. And then if we talk about, sometimes there's an additional video or something else that just kind of, um, uh, let me get two people in here. There's maybe some video that we talk about or something that I think is just going to give you some additional information. My talk in India was something I was just really passionate about. I was so happy to be there. And then there is a quiz, and you can see the quiz is right here. You just click on the quiz. You do have to have a Google email account to take the quiz, and they're not that complicated. You do have to know what's in the slides, but look, it's an open book test. You can go back, you can look at the slides again, you can answer. There's a lot of them that say check all that apply because I'm primarily covering what's on the slides. The reason I'm doing a quiz is because I want you to basically, when there's a quiz, even if it's fairly easy, it's open book, it at least forces you to kind of regurgitate what we've done and then make your own. It's a proactive movement on your part that you have to select answers, and it helps just in that training process. So also when we are ready, when Family Forward is ready to kind of classify, qualify, certify, whatever you want to call it, that you've completed all the training, we will want to make sure that you have done all those quizzes. Also, at the end of most of these quizzes, I'm asking the question, is there, what's the most important thing you learned here? And it's helpful to me, even if you just write a short sentence about something that you learned in this process that you didn't know before, it'll help give me some guidance. All right, so then this one was the first one. And then the second one we did is this one, which is the trauma drama. How did the system develop? The class code for that is small p as in purple, small I as in Indian, 24, small r, 27. So that's PI 24R27, and that would be the class code. Again, if you scroll down, you're going to see, I had some great comments on there, but also at the bottom, you're going to see the Family Forward posted new materials. And if you click on that, again, you'll see the slideshow, the quiz. That when we did that training, we talked about the Molly McGrath video. We talked a little bit about Nancy Schaefer and Georgia Tan. So I've connected those videos just to, help you kind of understand the whole process and understand how we got to where we are with this system. And then finally, last week, we did the part one of tricks and tasks of child welfare. Primarily last week, we talked about cross-examination, objections in the courtroom, etc. And again, you click on the new material and you're going to see the same thing. The class code on the third one is small letters JRS 7S for Z. Again, JRS, that's J as in joy, R as in red, S as in slipper, 7 slipper for zebra. So that would be the final class code. And hopefully for those who are just now catching up with us and watching this video, they'll be able to capture those class codes and go back and catch up and do some of the work from before. Then I did create a channel just for these trainings, and it is the Family Forward channel. So the Family Forward channel, I'm not putting other videos on there. My other, just my regular Connie app Family Forward, I think is what the other one's called. It has a lot of other videos, when I do presentations, marches, speeches, show up places, etc. So this one is just for the training, and I will post these trainings in the Family Forward project as well as posting the Spotify links. All right, so now let's turn to this week's content. All right, let me get us in the view. I want to be in. Okay, so this week, another training that I labeled tricks and task, because I will tell you, after 28 years of litigation, it often feels like trickery. It's like you can never be totally 100% prepared. And trust me, after all of the training I had in law school and the preparation for law exams, and where I thought I knew all the rules and how all the rules were going to work, they don't really work that way at all. So we're going to do the best to kind of cover what the rules should be. And then just, I'll talk about a couple ways it doesn't work that way. And then after we finish recording today, if we have any other questions on that, we will go through that as well. So this will be part 2 of the tricks and tasks of dependency litigation. Now, I just stuck this slide in there. This one is from last week. And I put this in here again because evidence is so important. And we're going to do another training on evidence. Excuse me. I tried to click the wrong thing there. Back. We're going to do another evidence training that's extremely technical. So these words, if you did not write these words down before, or you want to take a picture of this or go back to that training and pull up that slide and make yourself a few notes, these are going to be very important objections to remember, because if you're in this process yourself, or if you're helping a parent prepare, you're going to want them clued into these things as well. So, leading, hearsay, speculation, assuming facts not in evidence, cause for expert opinion, improper character evidence, lack of foundation, irrelevant, prejudice outweighs probative value, best evidence rule outside the scope of cross-examination. I feel like this needs to be a board game like Monopoly, right? And those all need to be cards that are laying in the chance file. But those are important terms to remember, and you're gonna be hearing them over and over and over because I want you to understand that part of evidence. So now we're going to talk about authentication of records. This is so important as an attorney, as I said in my office, and people and parents and everybody come in to talk to me, and I talk about the case and the facts of their case, and they would frequently tell me, like, well, I have a letter from a teacher. I have a copy of the document. I have a copy of the police report. I'm like, none of those are evidence. So it's so frustrating for something because so commonly in our everyday lives, we communicate with written documents, right? I mean, if you see a sales receipt from Costco, you assume that somebody bought something at Costco on that day, on that item, and the method of payment, like it's all there. But those are not authenticated records, and you cannot get those into court to use them. And so often parents their defense is not properly prepared because they have not gone to make sure that they have authenticated records. So why are these skills so critical? Again, this is a copy of a slide we had before. We talked about the cross-examination of social workers, but the second part is knowing how to authenticate court records. Parents often have defenses that are excluded for lack of authentication of records they want as exhibits. Not only that, but if you don't understand these rules, the opposite is also true. The opposite is that the state and the state employees may try to get records in as evidence that have not been authenticated. So parents need to understand and advocates need to understand the rules of authentication because they want to not only prepare a defense, but they want to be watching the trickiness, and this is why it's called tricks, all the trickiness of the child welfare agency. And so, what does it mean? Authenticating the records allows the court to consider the content of the records as evidence of the facts contained in them. I see one hand, but we are not going to discuss until we are finished. So, we'll have some open discussion about and put down your
Connie,
questions.
it's that we don't see your slides.
Oh, you can't see the slides. Okay, well, thank you for telling me that. All right. You don't see them at all. Okay, so I'm
Not
going to
at
go.
all. We've got your YouTube studio.
Okay, well, I'm going to go back a couple
I'm
here.
glad that she said that because I didn't even realize I was supposed to be seeing slides.
Okay, I'm going to have to stop share and start over. Okay. Well, okay, let's see if you have it now. Okay, do you see it now? No? It shows on my screen share participants. Do you see the slides now? Somebody says
I can
yes.
see the slides.
Okay. Okay. All right. Well, as I've said from the very beginning, technically we're imperfect. Okay, so we got slides. Thumbs up, somebody thumb. Okay, very good. All right, so this takes us back to, I'm just going to go back just a tiny bit here. Thank you for interrupting me for that. Where these are the objections to examination of witnesses. This is the one I was talking about. We're going to go over these over and over and over the course until these become like common terms for you. All right, so authentication of records is important because parents are unable to make their defenses if they don't authenticate records. And also, you've got to help your parent prepare to defend against what the state is going to do. And the state tries to get in unauthenticated records all the time. So knowing how to authenticate the records over on this side, this is part two, is to help prepare defenses. Okay, so this is where we were, I think. So authentication means, so what does authentication means? It means the records, it allows the court to consider the content of the records as evidence of facts contained in them. For instance, we're going to talk about a medical record, a school record, a letter or email or audio or video. So if you don't have some way to authenticate, is not a complicated words. It means exactly what it says. How
I
can you how can you show that this is an authentic document or authentic audio? Okay. It gets more complicated though as you go. All right, so what kind of records are going to be needed? You're going to need records that the state agency has created, medical records, sometimes mental health, school records, sometimes certificates and diplomas, especially where parents have been asked to do different types of classes, phone records, emails. There are other kinds of records, maybe from drug testing labs. There might be, I talked about receipts. I've had cases where parents do visitations with children and the agency says they never bring them anything. They never buy them anything. I mean, I actually tell parents, look, I don't care if you stop at MAPCO and buy some chips and, some apple juice and maybe some Skittles on your way to the visit. Make sure you save the receipt. So we'll talk some more about that. Documentation is so important. Therapy notes, supervised visitation, business records, drug screens, text messages. So documentation is so important because if you don't have documentation and it's all he said, she said, especially in these cases, you're going to get creamed. And even sometimes the smallest things. And when we get to audio recordings, I'm gonna give you a really good example. All right, so a subpoena for records with an affidavit. So when a subpoena is issued for records, it is called a ducis tecum subpoena. It includes an affidavit for the custodian of records. You have to be specific. You have to give ample time, and the sheriff can serve it, but anyone can serve it who is not a party to the case. So a parent can't serve it, but if the parent has a cousin, a brother, I mean, most of the rules in every state says any person over 18 who's not a party to the case can serve a subpoena. So this is an example of what a subpoena looks like. This is from Tennessee. They're going to differ a little bit, but the main characteristics of them is it's going to say it's a subpoena at the top. It's going to have the case number on it. It needs to have the court and the county, and then the plaintiff's name or the petitioner's name and the defendant's name or the respondent's name. You have to put here who it's to with the address. I always put a phone number in there. And then this one is kind of specific. So this one you can answer any one of these check boxes. It is a subpoena for attendance at a hearing, a trial, a subpoena for production, or a subpoena for inspection of premises, or a subpoena for deposition testimony. So you can actually do, almost nobody does it anymore, but you can actually do a subpoena for inspection of the premises. So again, let me just give you an example. A lot of parents are required to do supervision with their children in third-party locations. And you may want, and if the parent comes to you and says, this is a horrible place. I mean, DCS used to put them in a little room that was, 8 foot by 11 foot, and it just had plastic chairs in it. And they would say, this is a horrible place. I want to make sure I have pictures of this for the court, and they won't let me take pictures while I'm there. You could actually do a subpoena for inspection of the premises. Now, the most important one for authentication, of course, is subpoena for production of documents. So hang on, we get somebody else in here. So but when you're asking for those documents, you're going to put for the person, let's say this is to the pediatrician's office. So the pediatrician is Dr. John Smith. So what you put in two is you put in there to the custodian of records for Dr. John Smith, and then you put the address and the phone number. So it's always going to go to the custodian of records, unless it's a records that you know personally somebody has made, such as a visitation supervisor. If they've just given you the name of somebody who works by contract to supervise visitation, you may subpoena, put their name up there instead of custodian of records. All right, so remember when you do ask for records, this is so critical that you have to make sure the other side, and when other party, other side, when I say that, in what the cases that we're talking about is generally the state. So the state agency. So you have to give notice to the state agency when you are making a request for records. So a copy has to be given to them. You can scan it. A copy must be given to them of the records as well. What I always do is I scan them, I page number them. You can email them a PDF file. You need to include the custodian affidavit with the subpoena when you copy the records. So I don't know if I have a slide in here specifically on the affidavit, but if not, we'll talk more about that a little bit later. Now, once you have issued a subpoena, the other side sometimes will try to quash the subpoena. Always, I thought was a funny word in law. I always thought it should be squash and not quash, but it is quash. So the other side, once you have given notice to the state agency, they love to do this. As a matter of fact, they love to try to block your subpoena, especially if you're trying to get subpoenas of agency records, any of their contractors, a subpoena to come in and see the facilities. They're going to try to block all of those. And all that does is just slow everything down, which means you have to respond to the subpoena. You have to put a statement in the motion as to why it's necessary. And then you have to go to court before you get it. Just more chaos, just more ways to slow things down. But on the other hand, let me just turn that around the other way. Let's say the state agency was trying to subpoena the parent's mental health records from 5 years ago, right? So that parent, may want to block that subpoena. So they can file a motion to quash that subpoena themselves. So what can we subpoena? We can subpoena school records, medical records, x-rays, mental health records, supervised visitation records, CPS records, phone records, lab records, drug testing. Remember to direct it to the custodian of records. Allow 4 weeks for them to produce it. Include a records affidavit. Tell them, let them know in the notice that you will receive the records electronically and use Adobe to scan and number the pages. Okay, so medical records. So there are limitations on the use of records. For instance, with medical records, what is admissible is statements that are made for the purposes of diagnosis and treatment of the patient. Medical evidence can also be x-rays, temperature, observations, like somebody had a rash, the admission that was paper that was completed by the patient, why the patient said they were there. Social worker notes can often be admissible, which you have to be very careful of because right now I have looked at so many medical records and you have to be so careful because those medical records are full of dozens of people, like all kinds of people. The social workers change every shift and they might be different notes. So you want to make sure you're paying attention when you look at those records as to who is actually completing the records. What's not admissible is the statements of other people who are not provided by the medical providers, such as the CPS worker. So if the CPS worker calls a medical provider and says, this child has been complaining of a sore throat at the foster parent's house, then that is not admissible. So you have to watch for statements by third parties. And believe it or not, they're in there more than you think. So, what is admissible notes of hospital social workers? This is a good one. I love this one when they say the child was comforted by the parents. I've had this shown up. I think they've actually started eliminating it from the records because it's so valuable for the parents to have that in there, especially if it's a medical thing where the child's been brought in for, fractured ribs or something, but the child is actually comforted when the parent picks them up. Notes about discussions with CPS workers, such as called CPS. I think that is admissible. And that kind of tells us we want to kind of look for those so that we can find out what kind of information they were given CPS when they made that phone call. What's not admissible, this is very important, is in the records, typically by the social worker, but it will say something like social history provided by the parents. This, they don't record these conversations. This is where a lot of parents in medical kidnap cases get all twisted up and get, um, and they get snafu'd, I guess is the best word I can say, is because they try to give the medical providers good information. And then that's where you get into this, like, oh, the baby did, wasn't breathing well yesterday, but, it looked like they were going to be okay, and the baby actually had severe pneumonia or something, right? I mean, you just have to watch very carefully for what the hospital says the parent said, and make sure the parents have the ability to address that. Okay, so there are certain HIPAA protections for mental health records, and there's limitations on access and the use of mental health and substance abuse records. And this is why I say it's really important for parents to to bring out their objections, to ask for protective orders. Especially, they like to go back years. They like to say, well, 8 years ago, you had a emergency hospitalization. And those records, if somebody had a very stressful time in their life and maybe lost their job, had issues with unemployment, couldn't pay their bills. I mean, they could have had a breakdown and ended up maybe in a hospital for a short stay. But that, if they've had a successful life since then, or they've been functioning since then, those really are not relevant. And so those mental health records should be protected. The same thing with substance abuse records. Substance abuse records are also protected under HIPAA. And when CPS becomes involved, one of the first things that they do when they meet with the family is they flash in front of them releases of information. And you look at those releases of information, they're usually front and back, and they say just sign here and sign here. There's like two places to sign and date. But there's a whole series of checkbox on one side of it that describes the records that can be accessed. And then the other thing is there's always a blank on these forms for either an expiration date or a time period limitation for the records. For instance, you can put on that form, records not in excess of the last 12 months, and you can put an expiration date. I typically put an expiration date on their release of somewhere between probably 45 days is a relatively good time period to put, even 30 days, because if they need to get the records, if they really need the records, they should be able to get them within that period of time. And also, though, make sure that you write on the release that whatever is sent to the agency is also copied to the parent so they know exactly what's been received. So, challenges with mental health records, objections to privacy. So the guardian ad litem will often if you try to get a child's mental health records, you often are going to be faced with a guardian ad litem who's going to object to the privacy of the child. This is a real contest, and you are looking at uh, an argument between, well, the child is a minor and the child really, the mental health of the child is relevant, and we need to see if there were some other issues, particularly the mental health records of the children once they are taken into CPS custody. So once the children have been removed from the homes and the parents have no idea what's happening to them, part of those questions in discovery need to be, is the child getting mental health counseling? Almost every perm plan I've seen, they've got counseling for the parents, counseling for the children, and yet they refuse to turn those over. And sometimes they'll put that in the perm plan, and then if they feel like there's a savvy parent or somebody who's going to request those records, they never take them for that kind of counseling. Or when you get those records, you're going to find out it was in-home counseling, for 20 minutes every other week or something crazy ridiculous. But you don't want them to go to court and say, oh, yes, this child has been in counseling twice a month, for the past 10 months, right? And you have no records of it, no records. A lot of mental health records are illegible. I swear, I don't think I spelled that right, but I swear a lot of these people do this on purpose so that you cannot read their records. There's one psychologist in Nashville that the longer I saw him, and he was often referred to in court, and the longer I saw him, or the more frequently I saw him do court appointed evaluations and therapy and stuff, the sloppier his notes got to be, so that you could not read them until you went to depose him. And then, of course, he could change the records to be whatever he wanted because he would put like really cryptic notes in there that you couldn't decipher at all. So having illegible records is a problem. And if somebody gets court appointed to intervene, that's one of the things I actually ask in the appointment order, is to make sure that all records are either tied or legible and are for review. The lack of diagnostic tools, this little image I have over here is the MMPI. This has been probably the most widely used objective testing, the Minnesota personality inventory, but it's never been approved for custody. So they use it a lot. I don't see them use it too much anymore in child welfare cases. There was a period where it seemed like a lot of parents were being ordered to do that. This is a test that is not franchised, but licensed. So anybody who does this test has a payment for it. Therefore, it makes the testing more expensive because they charge a lot to a base fee that then passes through the mental health provider, and you don't even get a breakdown. It's not like you get an itemized list. They just will say to you, well, it's going to be $2,500 for a psych eval, and they don't say, well, I have to pay the MMPI, I have to pay them, probably $400 or $500. So it is a test that is licensed. It's pretty expensive. This just kind of shows some of the scoring there on the bottom. I used to be able to read these off the top of my head. I can't do it so much anymore, but you would there's actually guides if you want to really get into it that help you know what all of these things mean. The lack or the refusal to provide raw data. So they have raw data that should be passed from one mental health professional to another. They do not like to do that because it challenges their opinions. But if you ever have a psych person involved in a child welfare case and you want an independent mental health person involved, you want to make sure you ask for the raw data and you subpoena the raw data. Now they'll go like, oh, we can never turn our raw data over to lay people, but it has to be transferred so they can make observations. That industry, that mental health industry is so bizarre. So many ways. The testing result data is difficult to translate with chart scores, interpretations, etc. And I did my master's training in psychology, and I actually have a whole book on reading the MMPI. So, like I said at one point, I could read it, but I will say, if you look at these just as general, you look at these two bars in the middle, and anybody who scored inside of these two bars is considered normal. And if they scored outside of the bars, right, they were considered abnormal. And so, when you have a parent who's involved in a child welfare case and their kids have been stolen from them by the government who they thought they could trust, you almost always have a parent that is scores really off the charts for paranoia anxiety, uh, delusions. Like they're like, because they have these strong feelings that they didn't do anything wrong, so they must be delusional. So the mental health records are, and we'll probably do a whole training session just on mental health and psyche valves and how to break them down. Okay, so on phone records. So when you subpoena phone records, you want to subpoena, we've done it two different ways. We've subpoenaed phone records from the user. So, for instance, somebody could subpoena me to produce my monthly billing statements from T-Mobile, right? And so that would give them one set of information. A lot of people don't get the detailed records anymore. They just get the summaries, but I know online, typically you can get the detail. But a lot of times people will subpoena them directly from the provider. And I have found historically the providers such as Verizon, T-Mobile, um, who else? I don't know. Those have been the two. Who was it before it was T-Mobile? Because I use them all the time. Now I can't even think of it. But the phone providers have been
Sprint,
tip. Do what?
Sprint.
Oh, Sprint. Yeah, there you go. Thank you. Used to be Sprint. So phone providers have been typically very cooperative. And so they'll give you these detailed charts that shows you not only the incoming and outgoing phone calls and all the numbers, it shows you the date, time, duration. You can get the geolocation, which is they do it a couple different ways. The ones that I have received, it has like not a GPS a marker, but it'll have kind of a short term about the tower. It may say Brentwood 6 or Franklin 5, and you can find out where those towers are. It also gives you phone numbers, some very interesting phone numbers. Now, what are they going to allow you? A lot of these state caseworkers now have separate phones. They actually have state issued phones and not their personal phones. So I think now that they're using state phones, it should be free game. We should be able to get all the text messages that are being bantered around between caseworkers, investigators, supervisors, etc. So I put here must subpoena the phone carrier. As I said, you can try to ask for them from an individual. A lot of times they're going to say, oh, I don't keep them, I don't have them, but even though they can download them. Be specific as to the phone number, the account name, the date range, the data requested. So you would put the phone number in and you would say probably believed to be assigned to such and such person and the date range that you're looking for. Text data has been off and on. I have in the past received the actual text data, but then I've actually had some phone companies say text data is not saved. Now, who knows, right? I mean, I don't know. I'm not a technician, and most of us can't afford experts, to go through all of that with us. All right, text messages can also be easily faked. Now, this is when you're in the courtroom, and I have seen this happen, and I have used this against somebody in the courtroom who holds up their phone and says, I got a text message from somebody and they, said something horrible. They can change their name in contacts. We all know that, right? I can put your name under somebody else's phone number. And when it shows up in my feed and my text message is going to have your name on it. And then I can have that person send some ugly text message and then I can hold it up or screenshot it or turn it in and it's not you at all. So there are some objections that should be made to that. And I have done that actually in the courtroom. And I said, show us your phone and pull up, call that phone number. And when I did it, the phone number that they called was the attorney for the opposing party. So there had been some real funny business going on. So text messages, there should always be some kind of, if let's say, and here's a good example. A caseworker says, the parent is sending me angry messages, or I messaged them and they didn't respond to me when I tried to set up a visitation. these are the really good ones. And this is where, again, if an attorney doesn't know and if a parent is not prepared, then they go to court and a caseworker can say that and there doesn't seem to be any defense. I always have parents save text messages. Now, there are applications that you can put on your phone that will download all those text messages. I prefer just screenshots. It's kind of annoying to have to screenshot and then save it and screenshot and save it and scroll and screenshot and save it. And you've got to overlap it so you can. So it's a little bit annoying, but it's really that best message. And I know at least in Tennessee, they have said that a person can authenticate their own text messages that appear on their own phone. So, of course, this works both ways. You've got to be prepared to rebut if somebody is making fake text messages. All right, so photos, recordings, videos, text messages. Generally, they are authenticated by the person presenting the evidence. In other words, a parent is on the stand. I always have parents bring photos, make photos. I know our photos are all on our phone now. Send some of those photos to, any uh, office supply. I do Office Depot, Staples. You can print them to PDF or you can just send those pictures and get color copies made. Not that expensive to do. You can send them to Walgreens. I like to have the larger pictures more than just the teeny tiny ones, but I know if you try to get the larger ones, sometimes they're more expensive than somebody wants to pay. So, but you can get them printed. You can get a color copy of it at Office Depot. So photos always important to have. The parent themselves can identify those photos. I like family photos. I had 165 photos one time for a judge to see of all the activities and interaction this family had done together. And I think we picked about a 3 or 4 year period to cover. They'd gone to zoos together and just family events, and they were trying and not just staged photos, but those random photos you take of your kids, when they're at the zoo or they're at a school play date or something, so that you just have them in some type of activity or with a grandparent to show the relationships with others. The parent can testify to those. So we want them unadulterated. So we don't want the parents to write on the top of it, August 2024. We want them just totally unadulterated, have the parent hold it up, the parent explain what it is. Voice messages and yeah.
Can I suggest something? There's something that we were taught that's called a life book. So if you
Yeah.
could like start from like the beginning, maybe even, and then come up to date to where you had the child, like show a life book, like even the
Yeah.
people
Yeah.
in their
Right.
family
Right. Right. Yeah.
connections, make it strong on family connection,
Right. 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 Yeah.
and show the interactions and the events and things like that, and put the dates underneath, but in the book, like to show.
Well, no, I don't. I don't really generally want them writing on it because I want for a couple reasons.
No, not on the pictures.
I
I'm saying
understand.
in the
No,
book.
yeah, yeah, I understand. But if the state gets really nasty and ugly, they'll object because there's markings on the photos. So, but the other thing is it forces the parent to have that interaction. Like, I've had a couple times where, and the judges don't want to look at even 165 pictures. And so, the judge is like, I'm not going to have them explain 165 pages, but at least it forces them and it makes the parent have that discussion with them. If you have them all labeled, the judge isn't going to listen to anything. So I want the parent to be talking and talking about their family because they've been so demonized in this process that I want them to say, oh, here are the pictures from 2020, during the pandemic. This is what we did with the kids. And look at the judge in the face. You've got to humanize these parents during this process. So that's why I don't want to give them any excuse to either cut them out as being marked on, or for a judge to say, you don't have to go through all that with me. I can see, I can read, blah, 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 blah. So that's why we do that. So the voice messages and recordings, again, if it's somebody else has left a voice message, I know before we talked about lay opinions and expert opinions, there it is a lay opinion for you to identify a voice. In other words, if Shar left me a message on my phone, of course, I would have two ways to identify it. I'd be able to see her name on the voice message. Plus, you can, it is permissible to testify as a lay opinion about that as the voice of so and so. So they can, so as far as authentication of records, typically the parent, the person who has that message and that recording can authenticate it. And so you always have to have something to turn into the court, though, because when you're marking evidence, you can't just hold up your phone and play the message. You've got to have it already transferred on a flash drive or a CD or something so that after you play it, you can then hand it in, have it marked as an exhibit. I always also, the other thing that's critical is, let's say it's a voice message, that if there's a court reporter there, that you make sure the court reporter is transcribing what's in that recording. And you have to say it. You believe it or not, they won't do it. They'll just sit there while you're playing the voice message. So you say, I want to make sure this is in the record. The court reporter needs to take it down. All right, so marking the evidence, having it to hand in, the same thing with video. We have videos where exchanging a child at visitation, watching the child during a supervised visit. And you have to, the parent can identify it. Now, these tend to be a little bit more difficult to take down and put in the record, but I would still ask for it. So the parent's saying this, the child's saying this, etc. I want to give you an example of just how important this is. I had one particular case where this was a custody case between a mom and a dad, and the mom wanted desperately to cut the dad out of this baby's life. And the baby was, 1 or 2 years old. And the mother said, every time he comes to pick up the child, she screams. She doesn't want to go with him. And I said to the dad, I want you to get a recorder. This is probably 15 years ago now. And, before we were all recording on our phones, but I said, I want you to just go get a little recorder. I want you to start it when you're sitting in your car, put it in your pocket, walk up to the door, knock on the door, get the child and bring the child back to the car. And he brought me a recording that, and this recording was less than 2 minutes long. And as soon as he opened the door, the child was like, Daddy, Daddy, Daddy. And those kinds of things make so much impact. So when we're helping parents through this process, we have got to look for what are the when they're demonizing these parents and making them, sound horrible, what are the things that we can do to rehumanize them, to bring them back into the reality of what the parents have been trying to deal with? So little things like that can make a really big impact. Family photos. Now here is, I have put images on a page. I have put the date, but I don't put anything else. But I will put them in order, typically either in subject order or in like one that says school events. And I always like to make sure the photos include family members. Now, if you decide to print them this way, where you have more than one image on a page, the other thing I do is have the PDF pages numbered so that if you have 100 pages and you have a copy for the judge, you have a copy for the witness, you have a copy for yourself. It takes 4 copies of everything you do so that when you hand it to the judge, you can tell the parent, oh, look at page 46. Tell the judge about this one. Especially where judges, they love to cut parents off and not listen to parents talk, especially when they're trying to talk about their history with their family. And so if the judge starts getting cranky, or if the parent is kind of getting muddled, and there are times when parents are talking that they seemed a little monotonous or maybe too emotional, they're just not coming across well. This is the perfect thing to point them out to maybe some particular pictures that the attorney has tabbed or you've had the parent tab about particular events that are very important for them. So, and then, judges are always going to say, I've seen enough of this. I've seen enough of this. I can read myself. I know they've probably had good pictures with their families. I'm telling you that it's so hard to rehabilitate a parent when DCS has come in and impugn them. All right, so there's another thing that's called a where you can do a summation of evidence. This is particularly important. I have used this for instance, visitation records. I've used this for school records. Now, I love charts. I just love charts. I love to get things in order. And so I typically create charts with either Excel or Word. You could even do it with, I use a lot of Google Docs now because I moved from one location to the other and I can always pull up a Google Doc wherever I am. But this is a chart I created for school records. And so once I got the records, I put them in a date over here like this with the year, the month, and the day. And the reason I do it like that is because if I get them out of order, you can look at, as you learn how to use Google Docs, you can highlight these sections and then you can sort them by date because we're going to want to ultimately keep them by dates. And then I put just a short note over here about what is this record going to show? Is it about grades? Is it about attendance? Is it about parent involvement? And then a little description over here. Now, a lot of times I'll have another column which will say page number. So if you have voluminous records, we're going to talk about how do you identify voluminous records, and you have to have them page numbered. And so, I happen to have two very valuable tools, which is I have Adobe, which allows me to page number, and I have this, in my law practice, I bought a really nice copy machine that does all kinds of wonderful things. And so I have a copy machine that page numbers. So, I know that everybody does not have that. So, what are the ways that we can do it? And we're going to have to ultimately team up and so that if somebody has Adobe, and because now you have to pay for Adobe, you have to pay for a subscription. So if Family Forward has an Adobe subscription or somebody who's kind of specializing in that area of evidence preparation has an Adobe prescription, we will just scan records to PDF. We'll send them or upload them to either Dropbox is a very valuable tool to use or Google Docs. We'll upload them, then the person who has Adobe can take them, footnote them, page number them, and send them back or upload them. Because I know that as advocates who are not, they're not professionals, they can't afford big office staff and office equipment, but how can we combine these, the services that we can independently provide? And so maybe, one person is like, look, I've got Adobe, I'll, just scan me the records and I will work on this. I've got somebody who's actually willing to do that particular part and really focus on that. And there, would probably have a fee to do that. But even if parents have to pay a fee for that, the organization of those records, it's definitely worth it because they're often so important. And for instance, in this particular one, this was about, where parents are being criticized for either school absences or grades, but you've got to go get that record. You've got to have something. This also works for prescription records are very important, especially if you believe that if a parent is being accused of either uh, misusing prescription, sometimes we talked about subpoenaing records, but it may be actually a pharmacy record as well. We can do that. All right, this is, for instance, a summation I did on CPS records. So again, I have the date, I have the type, and here you see page numbers where I have gone and page numbered those CPS records, and then I put a little description. Now, here's what you can do. This is called, as I went back over here, I'm going to go back over here. This up here is called a TRE 1006. So it's that TRE is Tennessee rules of evidence, but you'll find some rule very similar in every state. When we talk about evidence, I will tell you most states pretty closely follow the federal rules of evidence. There'll be a few exceptions or changes here and there, but almost every state is going to follow federal rules. So when I talk about a Tennessee rule of evidence, I can pretty much assure you there's something that mirrors that in every single state. We may have to dig around for it or something, but it's there. So I have used what is called a TRE 1006 and prepared a summation like this with page numbers. And then once these records are admitted, if these records have been authenticated and they have an affidavit on them to show that they've been authenticated, then even the parents can testify to these records. So you can hand those records to a parent and you can say, you have in front of you the records, these have been authenticated. Did we prepare a 1006 summary? I always say we, makes it sound like me and the client. But I always have the client review it so they know what they're looking at. Did we prepare a 1006? And is this accurately describe what's in the records? And looking at this now, can you tell me, how many times the child was absent from school without an excuse? And then they're not fumbling through the records. And, a good judge really appreciates this and likes to have a summation. But sometimes, especially CPS, they love to object to this because sometimes they don't even understand what a 1006 is. So I put down here, you must attach a copy of all the records that you've summarized, and the records must be authenticated. You want to summarize facts only without editorial comments. So you can't say, for instance, on this one here about the visit, you can't say parent had a good visit at the CPS office. You just want to put down there an identifier to that page number. And then when either the CPS testifies or when the parent testifies and you can hand them those records, hopefully there's some better description within those records that would lead somebody to believe and form that opinion that they had a good visit. All right, finally, preparing records for court. Any record that you plan to use must be exchanged with the opposing party, which, as I said, is the state. I generally prepare exhibit covers. Well, I will put exhibit blank so that the exhibits are marked. Sometimes the courts and the opposing counsel rip those cover pages off and just put the exhibit stickers on them. Sometimes they do not. I still like to make exhibit covers because when you're handling the exhibits in the courtroom as an attorney or as a parent, it just makes it a whole lot easier for you to find the appropriate exhibit. Maybe you have tons of records, and then maybe you have buried somewhere in all those tons of records, a letter from something or a receipt from something, and you can't find it because you're trying to shuffle through all the massive amounts of records. Make sure you have enough copies. I talked about having 4 copies before, but you have to have a copy for every attorney, the witness, and the court. So that means if there are 4 attorneys, if there's a CPS attorney, a guardian ad litem, a mother attorney, a father attorney, that's 4 attorneys, the client, and the court. So that is 6 copies. It is a lot. Exhibits are massive typically. And I like to place each exhibit in their own file folder with a marker so I can more easily file it, because as you can see, with getting multiple copies on all of these, it's a lot of shuffling. If you have them in folders, you can use a banker's box or some kind of box where you can put file folders inside of and leaf through the top if you have a little tab at the top that identifies it. And then you need to know ahead of time which witness is going to need which record. I know that sounds easy, but it is not. So you may have, text messages between the caseworker and the client. Okay, so who do you want to introduce those records? Well, while the caseworker is testifying, you may want to confront the caseworker with those text messages. On the other hand, if they deny it, then you'll mark them and then you'll have your witness, your parent, identify those. So I know the more I talk about this, sometimes it probably makes your head spin a little bit because there's so many moving parts to it. And that's why I'm just like trying to get you tuned in to like, okay, look at this, look at this, look at this. And ultimately, as you hear this over and over and over, you'll begin to really tune in to all these nuances. All right, so what you need to show. So there is a slippery slope in child welfare cases, as we know. And a slippery slope sometimes means you open a door to something that is not that good for a parent. You know, maybe you think relative placement or kinship placement is a good idea, and then you open your mouth about that and you forgot to talk to the parent or client about that. And the next thing you know is the parents like shaking their head no and saying that can't happen. I have a really horrible relationship with my mother, my sister, whatever. So you've got to know what all the issues are going to be in advance. There's a lot of shifting direction in cases. There's a lot of curveballs. They love to add allegations and they love to control the experts. So let's talk about adding allegations because this is a really slippery slope that's so dangerous. So CPS will file these petitions, and let's say, they file a petition about educational neglect and a pediatrician called in because the child had bruises, whatever, right? So they file a petition, they take the child, you're getting ready, you're preparing for an adjudicatory hearing. You get in the adjudication and you're just not even a lot of times parents and even the attorneys, they don't go back and they read that original petition. For the parents, it's painful. It's very traumatic. It's very painful. They don't really want to be constantly reminded of, how they've been treated like trash. For the attorneys, there's so many things to do, but you don't think about going back to read that original petition. But it's really important to do that because you don't want to get in the courtroom and then the CPS counsel starts saying things like, well, and we know they have an anger management issue and there was a domestic violence assault and those are things that were never alleged. And if the counsel and the parent are not ready to stop that right then and there, the court will say, well, you didn't object to it, so I'm going to consider it because and this is a huge mistake. This is made so many times. Again, just because if you're getting ready for final adjudication, you haven't gone back and you haven't said what were the original things that brought us here. Controlling the experts, of course, we already know that. They want to hire their own mental health people, their own drug labs, their own supervised visits. There are times, you've got to find out what those supervised visitation people are saying because there are times where you want to get your own supervisor or have somebody in the alternative supervise. All right, so that is the end of today. Again, all of our training is about educating, motivating, activating, and engaging. So all of you all know that the Family Forward Project is the Facebook group. Now, the YouTube, there is the Connie Regularly Family Forward, but the training is actually just on at Family Forward. All right, so you all have been great and very, very patient. I know I covered a lot. Like I said, sometimes it's very confusing. I know I will cover this topic again from a little bit different angle. I will probably talk about the actual affidavit that they have to do to authenticate the records. We just mentioned it. We didn't go into it in detail. So we will cover that as well as, like I said, evidence, evidence, evidence. So critical. We're going to go through those rules over and over. All right, we are going to, and thank y'all for telling all the technical errors today. Again, this is a work in progress, so I appreciate your patience. All right, we're going to stop recording and then we'll have some discussion.